I never served in the military, and I don't know firsthand anything about air-to-air combat or how planes defend themselves from missiles. But I do know from my readings over the years that in an airplane, a combat aircraft, one defense that it has against an incoming missile is something called chaff. Chaff is these little bits of reflective material that is designed to confuse the missile's radar and to cause it to explode on the chaff instead of following through to an airplane and to destroy it, which was its target. The truth here is an airplane. What the defense has told you is chaff. With that understanding, some of the conclusions that were just argued to you escape me. How two professionals emailing each other immediately before a trial means that one works all the time and the other is a 45-hour week with no work ethic, just asking random questions. No at all. I have no idea how you draw that conclusion because two people participate in an exchange. That exchange happened at a late time. That sample alone, I don't get the conclusion. Allusions to that effect and the volume at which you say something doesn't make it correct. Plain and simple. Speculation, which is now the subject, conjecture, supposition, wild guesses, opinions formed without the basis or with incomplete information, versus facts and evidence. I'm going to tell you exactly what evidence is in the law in the state of Georgia, which will be told by the judge during her charge of the law. But that, Mr. Lewis, doesn't say who gets to question whom. A homicide investigation is a broad and wide thing. It involves a number of parts. It does not involve blind deference to anyone, no matter how educated there are. And it can involve testing a theory. Testing a theory does not mean that you believe that one theory or another is correct or incorrect, but theories get tested. It's part of the process. Things are discussed. Any conclusion you draw from that is just that, a conclusion. It's a supposition. It's speculation. We have to operate this thing sometimes. The judge is going to tell you that the state does have the burden to prove every element of this case beyond a reasonable doubt. Now, what every element means is everything: the day, the time, the place. A case cannot be put up just in 3 witnesses, and the other 14 witnesses are not a waste of time. They are the manner in which facts are proven. And the state, beyond a reasonable doubt, has to prove every fact, every single one. Because if I don't have witnesses who say that this happened in Gwinnett County or that Tori was killed in Gwinnett County, then that fact wasn't proven, and a jury can't find someone guilty. So the state has to prove that fact, and it did. Reasonable doubt does not mean beyond all doubt. It does not mean that because one thing might have happened, because there's a possibility, because something is plausible, that is reasonable doubt. It is a doubt in the mind of a fair-minded juror who is honestly seeking the truth. Seeking the truth through all the chaff and all the countermeasures. It's not something that you have to look for. You don't have to engineer it. You don't have to speculate about far-fetched possibilities where guns defy the laws of physics and just ignore recoil. You don't have to do that. If there's a reasonable doubt, there's a reasonable doubt. There's not. Your job as a jury is to seek truth. Now, how are facts proven in a court of law? Facts are proven through evidence. The judge is going to tell you in her charge that evidence is direct and circumstantial. Direct evidence is, I see this pen. This pen is brought into evidence. This pen, like these shell casings, are direct evidence. These shell casings are the shell casings that were recovered from the scene of Tori's murder. The people who touched them, tested them, examined them, looked at them, that is direct evidence regarding these shell casings. Circumstantial evidence is proof of a fact through a set of circumstances. Does somebody see Austin Ford enter Yellow River Park? No. There's no direct evidence of that. Does someone see Austin Ford leave Yellow River Park in Tori's car, traveling from, I'm going to butcher the road or get the road wrong, but from North Deshong Road to his home at a certain time? No. There's no one who testified that they saw that. But he admitted those things. He admitted he turned off his phone. He admitted that he took the car, and he admitted that he drove to his home. That is corroborated by his Google information that has his cell phone pinging outside of Yellow River Park and then going dark. It has his cell phone moving in a direction from North Deshong Road to his home at a pace that is faster than the average walking pace. So circumstantially, it is proven beyond a reasonable doubt that Austin Ford was in Yellow River Park at the time when Tori was killed. Plain and simple. That is circumstantial. There is absolutely no difference in the law in the weight that you give a direct fact versus a circumstantial fact. A fact is a fact. Now, as I said, the state is required to prove all elements of its case beyond a reasonable doubt. And it has to do so by certain rules that are set out in a very large book or series of books called the Official Code of Georgia Annotated. There are rules about what the jury can be shown, how it has to be shown, how it is proven that the thing is what it's said to be. There are rules that apply to both sides, such as the use of the court's subpoena power to bring witnesses to testify in court. There are some rules that apply to only certain parties or in certain circumstances. And as you saw during the trial, there are objections. That occurs when the state and defense or the parties disagree about the application of a rule or whether or not a question or object or thing complies with those rules. It's just part of the legal process. It happens in most trials. The judge will tell you that you are the finder of fact. That is your job. The jury's job is to be the finder of fact. You decide who you believe. You decide why you believe them. You decide if they had the opportunity to see what they testified to hear what they testified to, if they know what they're testifying about. You base that on their demeanor, the way in which they testify. What's the manner of their testimony? That's for you to determine. What their motivations are, their interest in the case, and their personal credibility insofar as you observe it, and the probability or improbability of their testimony. You can believe all or part of a witness's testimony because, well, that thing you said here, that I believe, this other thing, not so much. That is your prerogative as the jury. I do want to make a side note about interest in the case and what that means. The state's interest in this case is the finding of truth. That's it. The defense attorney's interest in this case are the interests of Austin Ford. The defense attorney works for Austin Ford. His job is to present his case in such a way that it favors Austin Ford. Period. The charges before you are felony murder aggravated assault, and 2 counts of firearm during the commission of a felony. Now, what are the facts that we know? So we know from Dr. Terry that the gun was fired from about 12 inches away. 10 to 12 inches was her testimony. That is based on the powder burns and stippling on Tori's head after she shaved the wound, and that's something part of her external examination, which is one part of her autopsy, that was performed July 28, 2021. We know that the wound path was straight across Tori's head. It did not have any upward, downward, or left-right deviation. That essentially is a very fancy way of saying it went straight across. It severed a part of her brainstem, and that would have ceased her motor functions, both voluntary and involuntarily, what she described as almost instantaneously. I believe she said there may have been a breath or two afterwards, but there's no particular way to tell that. Suffice it to say, she would have died from that wound before she would have had the opportunity to voluntarily move anything, which would include dispose of the gun, get rid of her car, or cause the blood transfer that was found on her thighs. Plain and simple, Tori did not do that. She could not have done that. That's not possible. Dr. Terry concluded that she was lying in the position that she was in when she sustained that wound. That was based on her observation of the clothing that Tori was wearing when she was found. There were no drag marks. The particulate on her body, on her clothing, basically was still, as if it was just picked up, not as if she was dragged across it. That's a fact. Where the shell casings were physically located is a fact. Now, there's a whole lot about how they came to be, whether or not they're pertinent. But where they were physically lying is a fact. Circumstantially, Tori could not have been alone. So Tori was not alone. Tori did not move the gun. She did not move her car. Those are facts. Some direct, some circumstantial, but facts nonetheless. The gun was never found. That's a fact. The car was later found on August 1st. The car was found torched in a nature preserve in DeKalb County, literally burned to the frame. That's a fact. The defendant lied for 8 to 9 months to police, to Tori's family, to police, to Tori's family, to police, over and over again. That's a fact. He volunteered nothing during that time. He did not tell Tori's mother that her only daughter was left dead by herself in Yellow River Park overnight. There was contact very early in the morning, maybe 1:30, 2 o'clock in the morning, on July 28th, when Teresa was looking to see where Tori might have been. Austin Ford knew. The defendant knew that he left her by herself, dead, in Yellow River Park, and he just went home after getting rid of the gun, the car, changing his clothes. He even gave the police another person to look at. He brought Scoop up time and time again. Because don't look at me. Don't look at me. I don't want you to look at me. Look over there. Go look over there right now. It's Scoop. Scoop did it. We know that there were 2 shell casings present. No, we do not know how they came to be, where they came to be there. I cannot tell you if they are exactly where they were when they were fired from the gun. Can't tell you that. I cannot tell you if they were kicked. I cannot tell you if they were thrown, picked up, carried, if there were squirrels involved. I can't tell you those things. I know where they were and how many of them there were. Those are facts. I know, and it is a fact, that there were similar markings on the shell casings in where the primer would be, suggesting that they were fired from the same gun. They were the same brand of ammunition. That brand of ammunition could be found in Tori Lang's gun box in the form of live ammunition. Those are facts. Kia Jimenez described for you how a semi-automatic handgun works. That the primer is struck, the bullet and particulate matter and flames and a lot of noise come out of the muzzle of the weapon. The shell casing is ejected from the side. How a semi-automatic handgun works is a fact. The fact that they eject shell casings is a fact. Those shell casings do not, admittedly, travel in any particular direction. They are more likely to throw back and right than they are forward, but I suppose that's possible. Nobody said it didn't. If I stood here and emptied the magazine of a semi-automatic handgun, the shell casings would not land in a neat pile on the floor. They would be kind of in a cone of uncertainty like the path of a hurricane. Some over there, some over here, some going to go a little further, some going to go a little shorter. That's still a fact. We know what the condition of the ground was. We saw it. It's wet and compact. There's mulch, there's leaves, there's particulates on the ground. It's not a tile or linoleum floor. It is not a smooth, uninterrupted surface. Based on Dr. Terry's physical findings regarding the wound, its path, and how far away the gun was when it was caused, we know the exact position of the gun when it killed Tori. Because Dr. Terry found that she had to be lying right there. That the wound was caused from a gun 10 to 12 inches away. So we know actually, which is kind of rare, to know exactly where the gun was positioned. What we don't know, based on Dr. Terry's findings alone, is who was holding it, how they activated it, whether they were laying down, sitting, standing. I can bend over and pretend to shoot it this way, that way. I can get down on the ground, and we're still not going to know because that's speculation. Assuming that the defendant was standing and bent over, assuming that he was prone on the ground, belly first, with the gun pointed that way, is speculation. Assuming that it had to be Tori and that she activated it with her thumb, with her finger, with a stick, all of that is speculation because science doesn't tell us that. Science tells us the gun was 10 to 12 inches from her head and what height the barrel was at. It can't tell you where the ejection point was pointing, whether it was pointing straight up in the air. But we can draw some conclusions from certain things. We know from the expert, Kia Jimenez's testimony, that generally speaking, firearms throw up and back, or semi-automatic firearms throw up and back. So if the ejection port was facing up, it is more likely that the shell casing would have gone, in this case, to my left. If it is pointing directly back to the back of the courtroom, it is more likely that the shell casing is going to be on my right where you can't actually see where I'm pointing. Back here towards the defense table. That doesn't mean that I can tell you that it absolutely was there and the shell casing landed absolutely where it did because of which way the ejection port was. But I know which way they tend to throw, and I know which way it is more likely that that ejection port was facing. So it is, if I've got a shell casing back here, it is more likely the ejection port was facing in this direction than it was in that direction. No, it's not a fact. It's a supposition based on a theory based on the physical evidence. That's not a wild guess. It's a logical, reasonable conclusion based on the evidence. We know that the blood on Tori's thigh was her own. We also know that it was liquid when it was deposited. Now, why does that matter? Well, much ado was made about a void in the coagulated blood. Now, the photograph that we looked at was a photograph that was taken after Tori was murdered and after she'd been in the park overnight and maybe hour, 2 hours after police had arrived on the scene. Dr. Terry told you that blood, when it comes out of the human body, is in a liquid form and it takes time to coagulate or clot or solidify. So over time, it got into that state. In that photograph, that blood had 6-7 hours to become the state that it was in. It was not in that state when Tori was killed. It had to be in a liquid state because that's how blood works. I don't suggest anybody go back in the jury room and cut yourself just to prove that particular theory. We know that the only thing Tori had in her system was phentermine, which is a drug that's prescribed for weight loss. It's a stimulant. And there was no testimony that it would cause hallucinations or any kind of wild behavior. We know that the defendant turned his phone off on the way into Yellow River Park. We know that because he told us, and the records corroborate that. Now, the reason that he gave is not corroborated, that is not a fact, which is that he turned it off because he was scared. That doesn't make any sense under any set of circumstances. Scared is an emotion. It can lead you to freeze. It can lead you to panic. It can lead you to act. But to turn off your cell phone? Turn off, I'm scared, so I'm going to turn off my cell phone. According to his statements, my friend has a gun and is driving me some unknown place, and I'm scared. So I'm going to turn off my cell phone. And we know, and it is a fact, that he lied about, concealed, evaded, and hid his knowledge about Tori's death from everyone around him, everyone he knew, and everyone who contacted him. Tori's mother, the police, period. Went to a funeral knowing that he'd left her dead in the dark by herself in Yellow River Park. Did not call her mother, did not call the police and say, my friend, she took the gun, she killed herself. He didn't say that, because that's not what happened. Now, what is speculation? As I said, that's an opinion that is formed on the basis of incomplete information or in the absence of information. Whether or not a stovepipe occurred. There is literally no physical evidence that a weapon stovepiped or that it was cleared anywhere on that scene. That's a wild guess as to how something may have happened, based on exactly nothing. What object may have laid in blood at one point or another? We know that there was blood on the ground. We observed a spot of coagulated blood and a spot where there was no blood coagulated. It is speculation to say that there was an object there, that there was another object there. We see, and I'll show you shortly, we see that the ground is not solid. Blood may absorb into the ground in different places. It may deposit on other objects. It does not exclude the intervention of wildlife or small animals, rabbits, squirrels, anything that may be alive in the park. We know that Tori was alone from about 11:46 until 6:30 in the morning. None of those things can be excluded. So to say, and go up to the screen and say, oh, the gun must have been this way, and look, it fits. It's speculation based on the way you want the evidence to be for your client. It is a fact that the defendant left with Tori. It is a fact that he left again that same night after Tori had been murdered and was wearing pants instead of white shorts. It is a fact that he returned later on, now early into the next morning, now wearing a different top. Those are facts. Now, this is the photograph that's largely in question. Now, this illustrates several things. This is the wound on Tori's head. That was caused by a firearm 10 to 12 inches away because of those little marks are particulate matter from the weapon that killed Tori. We all know why. I don't have to reiterate that again, and why it was the distance that it was. What is in dispute, or what is not known, is what, if anything, caused there to be blood coagulated here, but not here. We see sticks, mulch, it's a leaf right there, a leaf partially buried right there. If you look at, in the corner near Tori's elbow, this is not smooth ground. I'm not even sure it's dirt. It might be mulch. But there's clearly blood absorbed into the ground in some place. That's also a fact. That looks to be part of an acorn. There are other things on the ground. And to sit here and say that it had to be a gun, and it had to be this way or that way, that's speculation based on the way someone wants you to think about what evidence there actually is. But that's all it is, speculation. I know there is blood coagulated in one spot and not in another. What I do not know and what is not a fact is why or how. We know this ground was compact. We see debris of some kind all over it. There's sticks, there are small patches of growth, mulch or whatever this is. That appears to be dirt. There are plants near the base of the tree. We know the ground was in such a condition that even though by this time there had been multiple police on the scene, EMS, that nobody was leaving footprints. that's a fact. That's something that we know. Dr. Terry has encountered 10,000 or examined around 10,000 bodies as a medical examiner. She has taught medical examiners. She has taught her end of death investigation to police. There is no question that Dr. Terry is an expert in her field. That field is forensic pathology. Period. She is an expert in her field. There's no question of that. Over that time, she has seen exactly one distant suicide where the thumb was used to fire a weapon. And that is the most plausible way in which Tori could have killed herself. That would have had to be to make that shot across the back of her head, straight up, not left or right, at a distance, would be with her thumb. That's exactly 1 in 10,000, and I believe, and the jury will recall if I'm right, that was actually a case study and not one that she directly examined herself. If it was one that she examined herself, and I'm mistaken about it being a case study, then that is 1 in 10,000, or 0.0001% of all the bodies she examined would have been a suicide in the manner in which the defendant claims that Tori committed suicide. Well, his lawyer does. Not the way he did, because that's different. Dr. Terry absolutely is qualified and is an expert and can determine that Tori sustained a fatal gunshot wound. What the path of that wound was. That her death was almost instantaneous, that there was no movement after her brainstem was severed, what position she was in after her death, and that she was not significantly moved or dragged after she was murdered. Her finding was made, I believe, finalized August 17th or thereabout in 2021. A lot of things happened between August 17th of 2021 and now. And the time when Austin Ford was charged with Tori's murder. The car was found. Officers interviewed, spoke to Austin Ford repeatedly. The records from the defendant's cell phone and Gmail account were obtained by Detective Carter. None of that was known, or the results of that weren't known, August 17th, 2021. Because Dr. Terry fulfilled her role in a homicide investigation. What does the scene and body tell us about how this person died, and what determination can be made? And I will concede to you, based on the physical evidence alone, and I'm going to stress alone, it can't be determined how Tori was killed, based on the physical evidence alone. But we have so much more than that. It is not, Dr. Terry is not a homicide investigator. She's not employed directly by the Gwinnett County Police Department. She is the medical examiner for Gwinnett County. She does her job, she fulfills her role, and she does so admirably. She is absolutely one of the hardest working people I know. I don't expect to necessarily get emails from the medical examiner at 8:55 at night, nor do I expect to respond to them, but when I get them, I do. Dr. Terry did. Her official manner of death was undetermined. So now we look at everything else. We got this part. Now let's look at the other parts. We know there were no other significant areas of blood. We know the ground was the condition that it was in. There's one blood spot on the ground, various types of dirt. debris from the trees, sticks, leaves, mulch, whatever washed up the last time it rained, all that. So we consider whether or not Tori committed suicide because Dr. Terry can't rule it out, nor can she find it to be the cause of death. Because if she could find it to be suicide, she would have ruled that it was suicide. If she could find it to be homicide, she'd rule it was homicide. So the suicidal narrative comes primarily and is repeated primarily by the defendant. While Tori's mother may have been concerned that she hurt herself and that she took her gun, we're talking about a woman who has just been informed that her beloved only child is dead in Yellow River Park and that her gun is missing. She doesn't know anything at this point other than those facts. So wild speculation on her part, emotional speculation on her part, can be expected. You're going to run through everything. You've just lost your child. There is exactly no evidence, none, that Tori asked anybody else to hurt her. The only person you hear that from is from the defendant. We look at the distance the gun was and the things that we know, and that the shot came while Tori was lying down, and that it came in the dark while she was staring towards the sky. And it doesn't matter if she was looking at the leaves, the stars. She was looking up. Science or nothing else can tell you what was in somebody's mind. I have no idea why Tori laid down. There is no evidence to explain why Tori laid down. There is no evidence that explains why Tori was looking up, what she hoped to see. Or maybe it was just looking up into the darkness in a moment of peace. Don't know. It's not a fact. It's speculation. To sit here and say, oh, it's a picnic and she couldn't see the stars and it was a picnic, that's speculation based on nothing. It's speculation designed only to serve the defendant. And when we consider what the defendant ultimately said in his interview with Detective Carter, why, if you're coming clean, why do you keep lying? Why do you still lie? Why is it you say she grabbed the gun off the ground and just shot herself in the head? That's what he says. While she was standing up, she fell straight back and somehow her braids magically just came out from under her head. It's ridiculous. Because he's still lying. He had to admit he was there because the cell phone says he was there. He had to admit he took her car because the cell phone says he was in a car. He told you he got rid of the gun in a pond by his house. A pond. By his house. That's what you do when your friend commits suicide. You throw the gun in the pond, right? Suicide looking way less likely, isn't it? The defendant is the one who tells us that he killed Tori. Does it say, I killed Tori? No. But his actions speak way louder than the words he told Detective Carter do. He didn't admit he was in Yellow River Park until she told him the cell phone put him there. He didn't mention getting rid of the gun or what happened to it until we knew he was there with Tori when she was murdered. He didn't mention the car until he had to. He paints himself with Detective Carter as this helpful, loving, caring friend who I was so concerned with her. I took the gun from her and I hugged her She just pushed me away, grabbed the gun off the ground, and shot herself in the head. Ridiculous. We know it's all a lie. We know it's a lie because he's been lying from the beginning. The only truth in what he said are the things that are proven by the facts we know. Everything else, everything that points to him being guilty of the murder he's guilty of, he lies about. Concedes what he has to and keeps lying. This is the cover-up of a murder. Period. End of discussion. What do you do when you've murdered someone? Well, you get rid of the gun. I can't have the gun found. The gun might point at me. It might have my fingerprints, my DNA. Got to get rid of it. They find the gun on me, they're going to know I did it. So I get rid of it. So I dump it in the lake. I got to get rid of the car. Well, the car was here. It's the scene of murder. It's got my DNA. Oh my God, I got blood in the car. I got to get rid of the car. The car's got to go. Well, what if the police ask me about it? Because they're going to find her. They're going to find her shot. Well, I can't tell them the truth. I can't tell them I was there. I'm sure not going to tell them I murdered her. So I'm going to give the police someone else to look at. Yeah. Who? Scoop's a bad guy. He's got tattoos on his face. He hits scams, does drugs. Scoop did it. Oh, wait, oh crap, I'm wearing clothes. Oh man, these shorts are white. Oh, I got blood on them too. I got to get rid of the shorts. Well, oh man, there's blood on the sleeve of my hoodie. I got to get rid of it too. You know what? I'm gonna try and act normal. I'm gonna act like this didn't happen. You know, what would a friend do when their friend is dead? Oh, well, I gotta call her mom. I'll talk to her mom. I'll go to the funeral. I'll do all the things. Ooh, go back to the scene. Back to where I killed her. I don't know about that. I know my best friend just died, but I gotta go play football. You admit what you have to. They got a fact over there. I gotta concede that. Okay, yeah, fine. I was there. I turned my phone off. The car and the movement. Oh, well, okay, I took the car. Why did I do that? Oh, she told me to. Yeah. She told me to. He says that she's got this plan that involves him disposing of the gun in the car. But he also says that it was some impulsive thing where she grabbed the gun off the ground. Hallmark of a lie, maybe? The car turns up in a field in DeKalb County, burnt to the frame. Nature preserve in DeKalb County, burnt to the frame. And the gun may or may not be at the bottom of a pond or a lake, remarkably down the street from his house. This is the product of conscious, rational, deliberate thought. It's the cover-up of a murder. We know he was there. He tells us, his cell phone tells us, and then he covers up a murder. This is now where you come in. You, the jury, the finder of fact. Seek truth using the whole investigation. Do not fixate on one of those little reflective floaty things in the air, explode, and stop seeking the truth claim. Every witness plays a part. Every witness has a small part in the investigation of a homicide. The thing about people is we all have different skill sets. One person may be an expert at forensic pathology. Another person may know everything there is to know about handguns for firing thousands upon thousands of them. one person may be trained to take all of this information and consolidate it and come to a conclusion. Every one of these witnesses knows something different, has a different background, a different education, a different skill set. You, the jury, who are actually kind of configured the same way, where you have people of different ages, different backgrounds, different skill set, different experiences, get all of these things. You get Casey Smith, who, yes, you know what? Casey Smith, she was or Casey Crisby now. Casey was a patrol officer for a couple of years, and she left and decided to do something else. But she was trained in how to rope off the scene, to make the observations, and call the people she needed to call. Sergeant Smith was the initial, and never were related as far as I know, the initial investigator. He played his role. He started the process of getting geofences and trying to narrow down who might have done this to Tori. But the case was reassigned to Detective Carver, who, although a new investigator at the time, certainly can't be discounted or pushed to the side because this may or may not have been her first homicide case. The facts that she discovered remain facts. Tanya and Teresa Lang knew Tori far better than anyone around her. They, unlike us, had the privilege of knowing Tori. None of the other witnesses knew Tori while she was alive. None of the witnesses, including Tanya and Teresa, told you that Tori was suicidal, that she was hell-bent on ending her own life, nor does a single word in any of the letters that she wrote to God. She prayed for wealth. She prayed for solutions to her problems that are common, like needing more money. There is nothing beyond the pale or out of the ordinary that's not the experience of the average 18-year-old girl. There's nothing to indicate that she would have come up with this elaborate, ridiculous plan to end her life and then, on some spontaneous urge, grab a gun off the ground, shoot herself from 10 to 12 inches away, while her best friend carries off the gun and the car and pretends it never happened. Because that's ridiculous. It's far-fetched. When you start looking at the 0.00001%, it starts getting a little further away, doesn't it? Mary Boone Perkins, the only thing, she happened to have a ring camera, pure coincidence. Dr. Terry, the two young ladies from the crime lab, and of course the entire Gwinnett County CSI team, Brittany Barrington, Kia Jimenez, and Abigail Hamill. Every fact that they uncovered and every piece of information that they gave you is part of the picture. The defendant's attorney just keeps saying Brittany Barrington because she said the shell casings weren't pertinent. Well, what that means is that she can't tell you how those shell casings came to rest 9 and 14 feet away from Tori's head. No one can. No one can tell you what happened to them from the time that they were fired until the time that they were found. That's just where they were. We know that. That's true. What it doesn't mean is that when looking at all the other evidence and trying to come to a reasonable conclusion that, we're going to try it on this side now, that when the ejection port of a weapon is facing to my right, that the shell casing being in that direction 9 feet isn't consistent with it, because it still is. Now, Does that mean that that's the underpinning of the theory? No. It's consistent with that theory. Everything else, the distance, the height of the gun, that's known. Where the ejection port isn't known by a fact. But that shell casing being there is consistent with this. And just as there is no evidence to show exactly how it landed there, there's no evidence to show that it was in fact moved there. When you look at everything, you don't come to the conclusion that Tori committed suicide. Tori could not have held the gun in such a way that that shell casing landed there. The defendant could and did. Whether it was what the defense attorney is calling assisted suicide or a straight-up murder, his hand was on that gun when it was pointed at Tori's head. His hand pulled the trigger. I can't tell you that Tori knew or didn't know it was going to happen. There's a lot we don't know, a lot the evidence doesn't show, but we have to look at what the evidence does show. The last thing that I don't want you to go in that room with is the memory of Tori Lang lying alone in Yellow River Park, murdered by the defendant. Ladies and gentlemen, 0.001% is not reasonable doubt. The only reasonable conclusion, based on the facts and evidence, not on blind speculation designed to help this defendant, is that he is guilty of aggravated assault, felony murder, and 2 counts of firearm during the commission of a felony. I ask you to go back in that room and find exactly that. Thank you, Your Honor.